Okay, I want to also talk a little bit about the anti-patient brokering laws in each state. So like I said earlier, we have the federal anti-kickback, anti-patient brokering laws, and then each state has their own laws. California has one. The majority of states, 34 states, have them. It's usually the smaller states that don't have a law, or if they do have a law, they usually just adopt the federal law. And I've used Florida as an example, because I get questions a lot of times from a Florida provider who will say, this guy in California contacted me and said, can you, hey, I'll pay me $500 and I'll send you all my patients every time. And I'm like, and my Florida provider says, well, the guy's in California, so does that apply? Because California only says it has to be a healthcare provider, a licensed healthcare provider. Florida says it's any person. So again, this is where you have to be careful of knowing the law in your state. So in Florida, my providers in Florida, you have to worry about Florida law. Even though the solicitation and the remuneration is being offered in California, you accepting it in Florida law is potentially a violation of the anti-brokering law in your state. And it applies to any person. And this is a huge, huge, broad issue, because that means marketers, it means attorneys, it means billing companies, it means anybody. So you have to make sure you know what the anti-brokering law in your state is. It's also important for how you set up your businesses. We get a lot of questions about, well, I have a lab, and I have a physicians group, and I'm starting a program in Arizona, and I have one in California, and then I work with this doctor in Florida. That's a complicated issue. And you have to actually, it's great that you want to start the business. I'll tell you, good attorneys will be behind you in starting your business, but they're going to tell you how to do it the right way. So for certain examples in Florida, we definitely recommend that practices have a holding company where it's all owned by one entity, so that there's no technically violation between referring things back and forth. It's one of the cleanest ways to do it. There are also safe harbors that you can have, that if you're taking third-party specimens, you want to be in compliance with those rules. So even though you're going to start a new practice, or you're going to merge practices and things like that, definitely sit with your counsel and say, am I going to be violating any of these laws? Because it may change the way you set up your corporation. And I just want to highlight that for everyone in the room. I also want to talk a little bit about medically unnecessary services, because you've probably seen denials for medical necessity at least once in your life, right? Never happens, right? Never, ever happens. So, and this is actually an example of where federal and state statutes tend to overlap all the time. So what I have seen is that the performance of unnecessary services have been considered a form of fraud. And what that means is that if you are performing services that are deemed medically unnecessary, it's generally considered both at the federal and the state level as fraud. And again, this goes kind of back to the downcoding example. This is a perfect example of that. Not providing a service and billing for it, that's fraud. So you want to be aware of that. And be very careful that your clinical staff is key on documentation. The other thing I want to highlight here again is an example of where the federal law and the state law contradict themselves. So federal law doesn't really prescribe, unless it's a federal government payer, any requirement for the collection of copays and deductibles. Well, everyone in the room is like, well, yeah, that's why do I have to do that? I shouldn't have to collect copays and deductibles. There's no law requiring me to do that at the federal level. And that's true. Unless you're taking Medicare or Medicaid, there's no federal requirement to collect copays and deductible. But again, going back to the plan in which the state originates from, the state in which the plan originates from, there may be a law that governs that. California is an example. So California doesn't require that the patient collect patient responsibility, but you have certain cases in which it does, because the plan in which the state governs does. So we've seen this a lot. So let me kind of break it down a little bit more. probably a lot of insurance companies have told you your failure to collect patient responsibility is illegal. And you can say, no, California doesn't have a state law that requires me to do that. But the plan itself, and remember going back to governing the contract, and if that plan is from a different state that does, you're required to comply with it. And I'll tell you this, and the best practice is to collect patient responsibility because it's just an issue you're going to avoid. But again, this is an example where you have to go back to the plan and you have to be aware of the state you operate in. And then I just want to highlight the diversity of laws. And so this is an example of how the laws vary in regards to time frames for recoupment of overpayments by insurance companies in each state. Each state has a different law that describes it, and each state's different. So Alabama, you have 18 months. In New Jersey, you have 18 months. In New York, you have 2 years. So again, be familiar with the state that applies. So if you're getting an overpayment request, the one thing you want to do is know all the states that govern the plans, or a federal law or ERISA governs them. Because then you can say, hey, you're asking for monies 4 years back, and this plan's governed by Alabama, and Alabama has an 18-month limitation, so technically this patient needs to be excluded from any overpayment request. It's nitty-gritty, but, and again, I have it up here to kind of highlight the diversity of issues, but just keep that in mind. So taking all this primer that we just did on some of the key state and federal laws, and I know, this is why we're in business. No, I'm kidding. This is why I have a job. But taking all these in, I want to kind of direct you on how to take some key points and go back to your practice and organization and implement some of these things. So let's talk about a practice plan. Like, what's your plan of action? You're going to learn the federal laws, or you're going to meet with someone and have a basic understanding of what all federal laws are that would apply to what you do. And like I said, the list that I have earlier is pretty much the ones I've seen apply all the time, but that's what you want to start. You also want to learn the laws in your state that apply. So if I'm in California, I need a primer, and this should be prepared by a licensed attorney in your state that says, these are the laws that I need to be aware of. This is how they apply. And then what you want to do is take those laws and say, I need to now incorporate them in how I operate. One issue we have seen happen time and time again is that you get accredited, or you go get your license from DCF or Health and Human Services here in California. And you go get JACO and CARF, and you're like, great, I am all set. I have everything in line. None of those agencies take any of these federal laws into account. So they're not taking into consideration any of the laws that affect how you get paid for services and how you treat patients. They are only concerned with their own book of regulations. So just having licensing and just having accreditation is not enough. You actually have to incorporate these state and federal laws independent into your policies and procedures. And then taking a time to train your staff. Like I said, I can't highlight that enough. You at the high level may be ready to go, ready to rear, and you understand what the issues are, but the layperson has no idea. They may not even know their own employment laws. So you want to take the time to create training and compliance protocols for your staff. And I'm going to kind of go into 3 protocols that I like for audits, investigations, and complaints, breaches of privacy and data, and then hiring and firing and medical records. Because I think those are 3 key areas that you're probably going to see the law affect you in your day-to-day operations. So let's talk about audits, investigation, and complaints. They can originate at the federal, state, or commercial level. Federal being if you're taking a Medicare policy, state Medicaid or state policy, state-funded policy. Commercial, any private insurer. And what you'll see are such allegations as the services you're providing are not medically necessary, the services you're providing do not reflect the services you billed. That's that issue with upcoding and downcoding. They're not provided by a licensed entity. They're reflective of enticement or a failure to collect patient responsibility, part of a kickback or patient brokering scheme. And all these things, you see them, and hopefully after today you kind of know what they mean when you see them, but they would scare you. They would scare the layperson. So, and this is what they are using to go after you. So what you'll probably see is that you'll get a letter, or you'll get a request for records, or they'll review your data and send you a notice that, hey, you're overbilling or underbilling. You may also find that your patients, if they're unhappy, can call their insurance company and complain. And then former employers, realtors and whistleblowers. Realtor is actually a term of art. It refers to somebody who initiates a complaint, basically, against a person for violating a federal statute. And for example, under certain federal statutes, if I'm a former employee and I believe you're engaged in a kickback scheme, I can actually file suit under what's called a qui tam proceeding. Independent, like me, I can go and sue you, and the federal government can say, well, we're going to investigate it, and we may agree to join the litigation, or we may say we're not going to join the litigation, but that employee can actually sue you, and you could actually be liable for violating the federal law. So it's one of these mechanisms that the government created in the law to allow third parties to help enforce the law. So it's something to be aware of. So if you really don't have clear training and protocols with your staff, and your staff becomes aware of an issue you're violating, you may have liability of that staff member suing you, and they, I believe, can keep up to 25% of the damages. So there may be financially beneficial for them to sue you. I've seen this a lot with a lot of the laboratory litigation. They've usually originated from somebody internally within a laboratory saying that, I know this guy's doing kickbacks and paying people and dividends and doing all these different things. And sometimes the government's been inclined to prosecute, sometimes they have not, but the person can still go forward with that. I believe the Millennium Healthcare case was one of those cases where that happened. 3 of their former employees initiated an action under qui tam. Does it have to be an employer, or can it be anybody? Anybody. I can sue you if I know you're doing something wrong. And you get 25%. Yeah, if I win. Yeah. There we go. There we go. Okay, I just gave everyone the greatest idea ever now. But again, just be, this is where training is important. You may also see subpoenas for records. If usually from a government agency, you'll get a subpoena. And then they may do interviews, phone calls, things like that. They will tend to call your slower staff, your receptionist, your marketer guy, the guy at your call center, and that's where you get tripped up, because the guy at the call center without any training is gonna be like, oh no, we'll pay for your airfare. Oh, we don't collect anything. What are you talking about? And now you've just basically had someone admit that you're engaged in prohibited practices under the law. So again, be aware of how things can be initiated. What do you do? I mean, I would say, of course, I'm an attorney, call an attorney. Call an attorney, make sure that they're advised of what the situation is. Don't openly say, like, I'm gonna give them information or cooperate right out the bat. It doesn't mean you're not gonna cooperate, but an attorney can help tell you if there's any potential liability that you may have, because the great benefit of having attorneys is if you're doing something wrong, you can tell us. You need to tell us. So you want to talk to your attorney and say, hey, well, you know what? I was paying this guy, I am paying this sober living for all of my patients' rent. Okay, now we have to address that. How are we going to phrase that? How are we going to take care of that? But that's an example of why it's sometimes beneficial to call an attorney, because they can help prepare you to how to address the process. You also want to advise your staff. I've had this happen so many times where their staff will continue to speak to people from insurance companies. Make sure you send out an email, something to that effect, saying, hey, we are under audit with XYZ. If anybody from XYZ calls you, you are to refer it to XYZ. So please make sure you do that. You may also want to prepare certain press statements. You want to have public statements prepared in the advice of counsel. And you definitely don't want to destroy, hide, all of a sudden don't have documents. That never helps anyone. It actually can be against you sometimes, just in general, like working towards a resolution. I had that happen with a client right now, and they couldn't find any of their documents. And, and who knows, maybe it's true or not, but they couldn't find all of their documents, so now it becomes this question of, hey, I don't know what the other person has already. So just do that. And then also look at your contracts, especially if it involves any third parties. So with the laboratories, that's been happening a lot, where a lab would be sued, but they would also name multiple treatment facilities, and if you're ever named, You want to look at your contract. If you have indemnification provisions in there that would cover fees and costs, if you have language in there that does that. If you don't, that's probably a practice you want to work to put into place so that when you're signing contracts with your medical director and you're signing contracts with independent third parties, you have language protecting you in the event of litigation that you're not going to come up with the cost of paying for it. Because it probably does happen. You see it a lot. We do a lot of like med mal stuff, and like so that happens, and we always have to go back to the insurance policy. But you want to be protected from having to pay out of pocket. The last thing you want to do is get named in a lawsuit by some Joe Schmo who didn't show up for treatment or didn't do something right, and because you had one patient, they name you. And attorneys will do that, because we've kind of done that already. So, okay, and then what to do if you're approached by a commercial agency. This is like a private payer. You want to respond in writing. You don't want verbal communication. You want everything documented. You want to assert your rights right off of the beginning. You don't want to initially agree or consent to any overpayment or audit request. You want to document everything. You should have one person who's responsible for documenting and communicating with the insurer. All documents should flow through that person. I've seen that issue. We had a facility under audit, swore they never got any letters, swore they never got any phone calls. Come to find out, their biller got it, responded to everything, that biller's no longer there. Now, we look like an idiot because we said from the beginning, you're wrong, you're completely wrong. But not unbeknownst to them, they responded, but because they weren't organized and they didn't have a process, it ended up affecting delaying their overpayment recovery. Again, don't destroy high documents, negotiate. Insurance companies don't always have the right position. I've seen it a lot of times. We had one case with an insurance company that didn't even realize they were doing anything wrong with their legal counsel and with their head of operations in the room. So they are dumb. I hate to say it, but they're dumb. They're probably as dumb as all of us sitting in this room trying to learn all of this. So you're not always like immediately on the defensive. There may be areas that they're completely wrong in. So you want to open a dialogue with the party that be. And sometimes, especially in our industry, they're uneducated about how substance abuse and mental health is different than major medical or hospitals or private physicians. So you have to educate them and say, listen, no, you can't just step down a patient from detox to IOP after he's been detoxed for one day. What are you're trying to kill the guy? Like, they don't know. We've seen that happen a lot, especially the people in SIU, which is the special investigation units, don't know what the clinicians are doing. They will always have to go back to their clinical team. So negotiate and open a dialogue and say, tell me what it is you're trying to find out. Because more likely than not, it helps you understand what the issue is. It helps you prepare for the issue. It gives you some bargaining strength to say, like, well, listen, I can change that. If you're worried about my website saying residential, I can change that tomorrow. But you can't just say that you're going to take all my money back because of my website. Things like that. Real quick, I just want to highlight, actually the slide was supposed to be earlier, sorry about that, but there's, you have potential civil liability and you have criminal liability. So civil liability involves like breach of contract claims, they're not paying for certain services, they're requesting money back, they're requesting damages. Just because you have a civil suit brought does not mean you're criminally liable, and vice versa. Criminal liability, of course, you never want to have to deal with that because that can involve fines and jail time, et cetera. But an insurance company cannot make you go to jail. First of all, there's a lot of steps that have to happen in between there. Because one, they have to sue you, or they have to report you to a government agency in which they can allege that you have violated a criminal statute. Then that government agency has to say, well, we're going to investigate this violation of this statute. And then the government agency has to bring charges. The state's the only one who can bring criminal charges against you. And then the state, if they bring criminal charges against you, have to prosecute you. And then after the prosecution, then you go through that whole process. That's completely separate and apart from the insurance companies. Now, the only thing I will give you as a caveat is that Medicare and Medicaid, they can do whatever they want. So just be careful with Medicare and Medicaid. But a commercial insurance company cannot send you to jail in 2 weeks. Because I've actually had that question, and you're okay. You're not going to go to jail. But they may decide to sue you, or if you don't negotiate. And if they decide to sue you, they have to litigate against you. And if they win against you, then they can claim damages, but they can't send you to jail. Okay, so how do we use the law as protection? So just because you're under investigation doesn't necessarily mean you violated the law. Again, this was kind of the balance billing earlier requirement that we were talking about with just because you have to or are forced not to balance bill, that example. The other thing I want to highlight is assert your rights, determine if the request is valid, request the information. ERISA and state statute give you power. So if you know what ERISA says, you can say under ERISA, I'm entitled to X, Y, Z. I'm entitled to all the plan documents. I'm entitled to your overpayment extrapolation data. I'm in what they call their rat stat data. I'm entitled to different pieces of information to determine if what you are saying is true. And they are required to do that. And if they fail to do that, now you put a burden on them. If they fail to do that, that helps you because you're saying, well, you didn't give me the data. I don't even know if these are my patients. I've had that happen this week with 2 facilities, not even their patients. Overpayment gone. So it's an issue you have to be able to say, I can assert my own rights. You want to also put them on the defensive. If they're violating other rights while claiming something against you, you want to say, hey, you may be saying I owe you money, or you may be saying I'm practicing illegally, or I don't have a license. Let me tell you why you're wrong, and let me make it known. The public, involve your patients. Your patients are your strongest asset, especially if you have a good relationship with them, because they're the ultimate one who's going to be screwed. Well, I mean, you know, you're going to be affected too, but they're really in bad positions most of the time because they're the ones coming out of pocket. They're the ones trying to get help. They're the ones who don't understand that. They don't have the benefit of this lecture. So, you know, you want to say, let me work with you and create a policy with your team to help them do that. And I'm just going a little faster because I want to give us time for Q&A. Okay. All right, so I want to give you guys an example of, this is where you can actually put someone on the defensive. Cigna is one of the insurance companies who have said that if you fail to collect patient responsibility, that you're committing fraud, right? You go on Cigna's own website, it says right here at the bottom, patients may not be able to afford insurance copays and deductibles because they may not have a job as a result of their illness or fear that they will lose their job. So this was something I sent back to Cigna saying, well, listen, let's talk about this because you're putting all these requirements on collecting patient responsibility. But on your own website, it says X, Y, and Z. And this is just an example. If you take some time, you can probably, defend your actions. And this is an example where they're contradicting themselves. So don't be afraid to fight back, which is actually my next slide. So yeah, don't be afraid to fight back. There have been cases that have been won against insurance companies. I'm a lawyer. I die to litigate these cases. I can't wait to really nail one of these guys one day. But I will do it. I am willing to do it because it drives me insane. And I'll give you an example. Right now, Optum has a policy where they will not quote out-of-network benefits to any out-of-network substance abuse provider. And this Optum, so they're giving people an issue with quoting for benefits when you call. They're saying, because you're out-of-network substance abuse, we won't quote you benefits. And I'm like, well, let me tell you all the ways that this is wrong. Well, talking to Optum makes no sense. So now you have to get a third party involved. And so we've gotten DHS involved, we've gotten the CMS involved, and they're still like, okay, we're still gonna continue with this. We're working on the issue, but that just kind of goes to show you, it's really hard to do this, and we love it, so if you ever have questions or things like that, our firm is more than happy to help you with that. But you can win. So CMS and DHS right now are trying to enforce regulatory change with Optum to change their policy. We're waiting on a response on that. We should probably get that by next week. But we had to get third parties involved. We had to fight this issue and say, no, this is wrong. And it was ironic because I'm on the phone with the DHS and Parity Enforcement Division, and we're calling Optum together, and she's saying, I'm calling from the federal government. And, they're like, hold on. So, don't be afraid to fight back or reach out to other people, see if they have common issues. Like that's, we took this on because one of the guys was just like, I can't get benefits anymore. I'm like, what do you mean you can't get benefits anymore? So, and then, like I said, there have been cases. This North Cyprus Medical Center case is the earlier case I was talking about, where they're going to actually litigate the issue of downcoding, hopefully, if it doesn't get tried or dismissed or something else doesn't come up. But that was one of the issues brought up because this is a case with Cigna. Cigna alleged that this hospital had downcoded, and that was fraud. And the hospital said, well, you also didn't pay me, and that's a violation of the state statute. And me downcoding, because I deem that the patient needs more services than what you're requiring, is not fraud. So that's one of these cases that's in litigation right now. Hopefully we'll hear something about that soon. Medical records. I want to talk about medical records too, because there's really no standardized medical record. I've seen all kinds of medical records. I've seen back and napkins medical records. I've seen 50-page assessment medical records. So, the key issues that usually come up with medical records are failing to document services, not having the appropriate staff sign off on the forms and protocols, not describing what you're actually doing. If it's not written and it's not signed, it never happened. And if you don't explain what happened, it never happened. And that's the general rule of thumb. There's also an issue with inconsistent information, so make sure that you have all these issues I want to point to are making sure that you have a protocol, that someone is looking at your record. Your record is going to be your key. You never really get a request for overpayment or fraud that relates to what you did last week. It's always what you did 2 years ago or 3 years ago. So if you don't have appropriate protocols that address how you're dealing with medical records and training for your staff, it can be an issue. So I want to give you an example. This is an excerpt from an independent audit that was done by an insurer. And this is how detailed the insurance companies look. So here you see that they're describing that there was no statement from the MD or the staff that described why the services were medically necessary or the frequency of drug testing. That could have been resolved if you had a protocol that made sure your form or whatever it was properly filled out and indicated why the patient needed medical necessity for testing, and it was signed. It could have been resolved, but that was an issue that they found. The group notes were somewhat vague. I've seen that a lot. I've seen group notes where like, patient participated today. Great. Was he sleeping? Like, I don't know. So again, being descriptive, making sure your forms are doing this. And I hate to say this, accreditation requirements don't make you do this. Licensing requirements don't do this. EHRs, as great as they are and they're awesome, they don't do this. You have to take the time with your clinical staff and say, let us create a protocol that addresses what the guidelines for medical necessity are, because nobody else will do it unless you do it. And then they're looking at some other concerns. The time that was actually spent to complete the services, they're looking at that. I've seen that a lot where, say, like, you're supposed to do 5 hours of services for PHP in a day, and you don't do the 5 hours because the patient left group twice to go visit with the psychologist. They're looking at that level of detail, which means you have to. There was documentation of 2 family sessions, but this is, again, just an example of the detail. This is for one patient, and this was just an excerpt of the audit that they did. There is a national association that actually accredits independent reviewers. So if you really wanted to have, invest the time in doing this, you can find an association or an agency or a business through that accreditation agency and hire them to come in and critique your records and give you guidance before you get it from the insurance company. Because these are the same people that they use. And it's an accreditation and a status that you have to have. It's a credential. Believe it or not, they're billing credentials. There's medical record credentials. So I would also recommend, if you don't feel comfortable doing that, enlisting the services of one of these independent accrediting agencies to come in and review your records. Again, some recommendations: making sure your staff is trained, making sure your forms are dated and signed, make sure you have processes in place to manage how the records are sent out by anyone. And then just always keep in the back of your head, just because you're meeting your state or accreditation guidelines, it may not be enough. All right, PHI and HIPAA. I have kind of like an acronym for this, which is weird. It's not really an acronym, but I remember from grammar school who, what, where, when, why. Like, I just remember that. I don't know why. But it actually applies perfectly in the context of HIPAA and protected health information. And I'm just going to touch on this briefly. But this is actually an area where the government is stepping up enforcement and breaches of privacy and protected health information. There are fines associated with breaches in data. You can also be subject to civil liability and a lot of damages by independent people who have had issues where it's been violated. So I recommend before this becomes a problem, you make sure you have protocols in place. So who? Always make sure you know who you're disclosing protected health information to, whether it be patients, family members, or third parties. Because who you are disclosing it to makes you make sure that you have the right release to disclose. So you can't just necessarily say I can disclose to anyone at any time if you're sending out substance abuse or mental health information. You have to make sure you know who you're disclosing those to. How and where? Another big issue, electronic. Everyone's going electronic. Everyone has emails now. It's so easy to send an email, because we've done it, I've done it. Just say, hey, like patient John Doe here has like a diagnosis of XYZ. Believe it or not, that's protected health information. And if I'm sending that over email and my email's not encrypted and something happens, then, or I'm storing it in the cloud, because everyone's in the cloud now. So you want to make sure that's good to go. Ensure that your staff knows what is considered private information. I had a question one time where it was, can I disclose to a family member what the medications that a patient was taking? And you can actually disclose that in certain circumstances. So you actually have to take the time and say, I need to tell my staff what is considered protected health information and what is not. So, because they didn't know. They're like, can I tell the mom that he's taking Zoloft or whatever it was? I don't remember what it was. And I'm like, actually you can, because you can disclose that information under HIPAA as long as it's not specifically prohibited by the patient. The patient hasn't said, don't contact that person. When? Make sure you know your laws and rules regarding storage and retention of documents. Again, going back to my maxim, don't destroy documents. Keep them for at least 7 years. I always highly recommend that. And then why? Make sure that you have protocols that correlate with the disclosure of information for the specific reason. So why am I disclosing this information? That makes a huge difference. If you're disclosing it to an insurance company, you have to have the forms that allow you to do that. If you're disclosing it to another facility, you have to have the releases that allow you to do that, things like that. So, take some time. HIPAA is actually not really that scary. Yes?
CFR 42 really is the standard we need to work to, because it's far more restrictive.
Yeah, HIPAA is kind of like whatever. I was just going to say that. HIPAA is not really crazy. There is a lot of, yes. The better you prepare, the safer you will be, because that is more restrictive than HIPAA. But if you're a normal guy operating a small practice, start with HIPAA. Start with HIPAA, learn what the rules are, make sure you have protocols in place, because it's becoming bigger and bigger of an issue, especially now that insurance companies are taking medical records electronically. You can upload them a lot of times now, things like that. So you want to make sure you're uploading them correctly. But yes, you're correct. All right, and the other thing I want to touch on are employees real quick. We do a little bit of employment law as well, so we've seen issues with providers and employees. And this is a unique space because what we have seen is traditionally a lot of people in recovery work in recovery. That can create potential issues. Like I said before, there's that new business plan that we just came up with that former employees who are disgruntled can technically air your dirty laundry. So you want to make sure you have processes to address with them. And the other thing is, like, say that you lose your medical director. He just decides, because we all know physicians are great. No, I'm kidding. He's just like, he's like, I'm not gonna come in anymore, or something like that. You want to have a protocol that addresses what happens if he hasn't signed his records in the last week, because now you're the one who's liable. So you want to make sure that in your contract with him, you have something that addresses that he has to complete all records and you have to sign off on it before he receives his last payment, something like that. Making sure, yes.
And you can do that with any coach.
Mm-hmm. I would do that with anybody. Whenever you're drafting a contract, don't just sign a contract. you may not change all the terms for it, but understand it. I know everyone's guilty of just signing and not knowing what they're signing, but when it comes to your practice and you're releasing information and having relationships with third parties and employees, make sure you have something that addresses certain situations. Like I said, one, termination, big thing. What happens after we terminate? If you're in charge of my data, how do I get my data? If you're responsible for servicing my staff, how do you service my staff? When does that terminate? What happens if you don't show up after you terminate? Things like that. So you want to address those provisions. The other thing you want to be careful of in those contracts, like I said, is cost. What happens if what the third party was doing somehow comes back to bite you down the road? How do I protect myself, indemnify myself, things like that? A lot of times, people just sign contracts because they think they can't negotiate the terms. I married an Indian. My husband negotiates everything. He got 7 cents off my lease payment. So like you can totally negotiate. So feel free to do that and say, these are my standard things. I need to have that protection in place for X. I need to have protection in place for Y. Take the time and do that. You may not change the entire document, but you're going to protect yourself. And then kind of going on to this hiring and firing, making sure that you have an employee handbook that governs policies and procedures, and that you have protocols that address how situations arise. We represent a mental health hospital, and we get calls all the time about the most random situations that have happened with employees. So, and it's always the last minute. My whole point of this presentation is try to encourage you to take all these issues that I've highlighted today and some of the brief explanations of the law and say, it's a waking up moment for me to spend some time and invest in compliance, because a lot of these issues will eventually happen to you. I want to put you guys in the position that when the issue happens to you, you know what to do and you can address it before you have to call an attorney on the back end, because that's when it costs a lot of money. So that's just like I want to do as my takeaway. We're also working with the American Addiction Treatment Association. It's a new association, and the reason I actually recommend taking a look at their site is because we're working with them to try to develop a lot of these protocols and forms to make it easier for substance abuse providers. So it's really geared towards operations and compliance, and hopefully we're going to have C4's involvement with that too to help encourage the dissemination of that information nationwide. It's a bunch of attorneys right now doing it. So I definitely take a recommendation that you look at that. And then hopefully from all of that, you'll be able to grow your business and do an amazing job and get those statistics down and help treatment and focus on what you're here to do. So with that, I'm going to thank you for your time. I'm going to open the floor for any Q&A questions right now because we have about 15 minutes. Thank you. Yes, you had a question?
Yeah, I just figured, so this whole thing that the industry is going where they offer scholarships for sober living so that you go to treatment, that's all illegal, right? Is that all?
It's not technically illegal. It's very technical. What you're finding is a lot of people offering a 501(c) corporation right now, where the 501(c), which is a nonprofit, is basically a fund to help pay for their patient responsibility. And there are provisions under federal law and state law in certain areas that allow you to do it, but it's highly regulated. I do know one attorney who's involved with that in DC, who is working with a 501(c). If your 501(c) is not working with an attorney with this, I would not work with them, because it's very complicated. And honestly, I don't even get into it right now. I know the basics. I would recommend against it immediately of my clients unless I spoke with the attorney for the nonprofit that was involved with this.
Are those for federally funded programs?
No, federal and commercial. The ones that I have been asked about are ones that deal more specifically with commercial insurers and being able, because the issue has been that patients can't pay for their patient responsibility. The standard is that Okay, so the standard for collection of patient responsibility, which only consists of the member's deductible or co-insurance or out-of-pocket under their member's plan, not their balance billing, is that you make a reasonable effort to collect. That's the general standard. Reasonable effort has not been defined by any regulation that says reasonable effort is 3 times and you collect 10% and it's X, Y, and Z. The best guidance I can give you is look at CMS's guidelines, and their standards for what they define as reasonable effort to collect is what you should be doing for patient responsibility. That being said, a lot of people now have been involved with nonprofits that have been set up to pay for these patient responsibility to the providers. Again, because I don't have a lot of legal involvement in those, I would just, as a starting point, if they don't have an attorney who's involved with it, it's very complicated. If they don't have an attorney who's doing it, then I would not be involved in it.